5 seconds to go. Start. In view of the above discussion and for the reasons stated above, the impugned judgment and order passed by the High Court is hereby quashed and set aside. The respondents are directed to consider the case of the appellant for appointment on compassionate grounds under the 1990 rules as per his original application made in July 2010, and if he is otherwise found eligible, to appoint him on the post of junior clerk. The aforesaid exercise shall be completed within a period of 4 weeks from today. However, it is observed that the appellant shall be entitled to all the benefits from the date of his appointment only. The present appeal is accordingly allowed. However, in the facts and circumstances of the case, there shall be no order as to cause. Before parting with the present order, we are constrained to observe that, considering the object and purpose of appointment on compassionate grounds, that is, a family of a deceased employee may be placed in a position of financial hardship upon the untimely death of the employee while in service, and the basis or policy is immediacy in rendering of financial assistance to the family of the deceased consequent upon his untimely death, the authorities must consider and decide such applications for appointment on compassionate grounds as per the policy prevalent at the earliest, but not beyond a period of 6 months from the date of submission of such completed applications. We are constrained to direct as above, as we have found that in several cases applications for appointment on compassionate grounds are not attended in time and are kept pending for years together. As a result, the applicants in several cases have to approach the concerned high courts seeking a writ of mandamus for the consideration of their applications. Even after such a direction is issued, frivolous or vexatious reasons are given for rejecting the applications. Once again, the applicants have to challenge the order of rejection before the High Court, which leads to pendency of litigation and passage of time, leaving the family of the employee who died in harness, in the lurch, and in financial difficulty. Further, for reasons best known to the authorities and on irrelevant considerations, applications made for compassionate appointment are rejected after several years or are not considered at all, as in the instant case. If the object and purpose of appointment on compassionate grounds, as envisaged under the relevant policies or the rules, have to be achieved, then it is just and necessary that such applications are considered well in time and not in a tardy way. We have come across cases where for nearly 2 decades the controversy regarding the application made for compassionate appointment is not resolved. This consequently leads to the frustration of the very policy of granting compassionate appointment on the death of the employee while in service. We have therefore directed that such applications must be considered at an earliest point of time. The consideration must be fair, reasonable, and based on relevant consideration. The application cannot be rejected on the basis of frivolous and for reasons extraneous to the facts of the case. Then and then only the object and purpose of appointment on compassionate grounds can be achieved. Stop.